that opinion by talking about in a constitution that is of an enduring nature, each generation can continue to read and apply and enforce it to achieve greater and greater freedom for more and more people.
That was an opinion that didn't rest on substantive due process, but worse still, adopted the principle that the state has no right to prescribe sexual mores. This is a proposition that has never been reflected in any society in the world that I'm aware of. And it's not reflected in ours today. We have laws against bigamy. We have laws against incest. We have laws against prostitution. We have laws. There's never been a society that didn't establish some sexual morality. And to say that it's a principle of our Constitution that the state cannot do this, when it's done it for 200 years and nobody has, and continues to do it today, and no one has thought it's unconstitutional. That's not a principle I would want to hang my hat on.
Well, the fact that something has been done for 200 years is not a basis for finding it constitutional. Racial apartheid as an example. But the important point was the holding, not that morality cannot be a basis for law, but the public morality, or what the community's majoritarian morals, can never be the sole basis for a law. So surely you could have a law against incest because there is another justification for that law other than morality.
What is that?
It's protecting individual freedom of choice and consent. Many incestuous relationships involve unequal power and therefore not true voluntarism.
I didn't know that we prevented incest only between minors and
well,
and
the
adults.
familial relationship is one that could very well undermine consent. The point is that law cannot be based, certainly not criminal law, only on the view of the majority about morality, because under our system it is up to individuals to make those basic moral determinations and not for society acting through the punitive power of the criminal law.
If you persuade your fellow citizens to that effect, fine, and abolish all those sexual laws. But persuade your fellow citizens. Don't tell me it has been imposed upon them by a constitution that nobody ever thought meant that. That's what I'm objecting to. It isn't a question of whether I like it or don't like it. It's a question of who decides.
Do you think that
who decides? If the people want it, fine.
Do you think that the framers really contemplated the situation in Texas, Nino, that a law that was struck down in Lawrence, that police officers would go inside somebody's home, watch an act of sexual intimacy between two adults in their own bedroom and arrest them and prosecute them and imprison them? You think that was in the contemplation of the framers as a legitimate exercise of government's criminal power?
I don't think any police officer would have proceeded in that fashion then or now. But that doesn't say that there cannot be a law against the subject. You're opposing the existence of the law to the manner of enforcing the law. They are two different things.
Well, the final question is based on the fact that there's obviously mutual respect here, and the question is a simple one. How do you two know each other?
How did that
Very well.
I don't recall where.
I think we first met in 1991, which was the bicentennial of the Bill of Rights, and we both participated in one of the Fred Friendly roundtables in which Nino continued to insist that the Bill of Rights should mean what it meant in 1791, and I was advocating a rather more progressive view.
It was Fred Friendly's thing. I didn't realize that. Yeah.
Well, to both of you, thank you very much.
Thank you very much.